Hunter Biden guilty of all 3 counts of illegally purchasing a firearm while addicted to drugs. Let's discuss. I'm Dave Aronberg, state attorney for Palm Beach County, aka the Florida lawman here on the MeidasTouch network. So we just got breaking news that Hunter Biden was found guilty, and it should not be that surprising because the law is cut and dry. Here's a look at the form at issue here in this case. When you purchase a firearm, the ATF requires dealers to give you this 7-page form. And on the form, it asks right here, are you an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance? And it says below it, warning, the use or possession of marijuana remains unlawful under federal law regardless of whether it has been legalized or decriminalized for medicinal or recreational purposes in the state where you reside. So that's a reason why a lot of people think that this law will be found unconstitutional, because you've got states around the country that have either legalized or decriminalized marijuana, but yet it's still a felony under federal law, punishable by potential prison time if you buy a gun while you're using marijuana, a legal drug in some states. So that's one of the reasons. You've got these conservatives on the U.S. Supreme Court and on the Fifth Circuit Court of Appeals in particular, where they like to expand gun rights. And any restriction on gun rights is something they cannot handle. And one restriction is someone who is using drugs. And so that's why this case put Republicans in quite a bind. Do they support the unlimited Second Amendment rights that a lot of them espouse, or do they go after Hunter Biden? I think that because of the potential unconstitutionality of the law, because of the fact that this law is rarely, if ever, used against someone as a standalone law, usually it's invoked as an add-on. Like, for example, if you're a felon in possession of a firearm, then the feds will throw in this statute too. They'll say, hey, and by the way, we found marijuana on you, so we're going to also charge you for that. But rarely, if ever, is it used as a standalone charge where that's the crime, buying a gun while you are in the throes of addiction. And it's very hard to prove. But the way they were able to prove it against Hunter Biden was because they used Hunter Biden's own words. He wrote an autobiography where he talked openly about using crack cocaine and other drugs around the time he purchased this weapon. So his own words through his book, through his text messages, through others, emails. They even got Hunter Biden's laptop, the infamous laptop. They even used that in the case to show his own words. That was his undoing in this case. But the fact that the law could at some point be ruled unconstitutional, and by the way, it already has been by that conservative Fifth Circuit Court of Appeals, it's already been ruled unconstitutional. But the fact that it could, the fact that it's rarely invoked in any case where it's a standalone charge, and the fact that Hunter Biden was in the throes of addiction and he did not lie about it on the stand. See, that's one reason why he didn't take the stand, because his lawyer did not want him to be punished harshly because he lied on the stand. All those factors, I think, are going to, cause the judge to avoid any incarceration here. And I know the judge is a Trump-appointed judge, but the judge here seemed to have ruled down the middle on a lot of these things, and I would be surprised if he got incarceration. Now, he's eligible for up to 25 years in prison and up to a $750,000 fine. I think he'll get a real fine and probation. But hey, we'll see what happens on sentencing. I think Hunter Biden's real concern is the IRS case in California. You don't want to mess with the IRS. I think that one is a tougher case for him. But I think in this case, he had a legitimate claim of selective prosecution. There was a plea deal on the table that blew up, and the Republicans were aggressively pushing to get Hunter Biden prosecuted. And so then all of a sudden you had these felony counts that wouldn't have been charged likely if his name were not Hunter Biden. If his name were Hunter Smith, I don't think this case would have been brought. But the judge in this case ruled against a claim of selective prosecution, and it was game on, and here is the result. Now, whether or not Hunter Biden should have taken the stand is going to be a matter of Monday morning quarterbacking. I actually think he should have taken the stand. I think the only way out for Hunter Biden in this case would have been the sympathy of the jury, would have been to get to at least one juror, where all it takes is one for a hung jury. And many people in our country have dealt with either themselves or their family members or a loved one with the evils of addiction and how painful it can be. And if he took the stand and looked the jurors in the eye and talked about his ongoing battles with dependency issues and drugs and how he tried to overcome them, and he tried to go to rehab, and his family has been working with him to be a better person, and he's trying, I think that could have reached at least one juror. And I think he should have taken the stand for that reason. But he decided not to, because his lawyer probably said, if you do that and you're caught lying, then you could be charged with perjury, or at the very least, a judge could throw the book at you during sentencing. So that was the calculation they made. But, there's something called jury nullification. And although it's not told to jurors in the jury instructions, jurors have the ability, if they want to just say, no, I'm not going to go there. I feel sympathy for him. I'm not going to convict. It's every prosecutor's worst nightmare. We hate that because jurors are told to follow the evidence, the facts, and the law, not to base your decision on sympathy. And the jurors, though, could go into the deliberation room and just say, no, I'm not going to do it. My mom, for example, had a DUI case. She was on a jury years ago, and I was a teenager, and it was a teenage defendant. And she came back and she said, no, I couldn't vote to convict because he reminded me of you. Wow. Well, first off, I don't get DUIs. But secondly, that's jury nullification, and you're not supposed to do that, but the jury has a lot of discretion to do what they want. So it happens. And I think it could have happened in this case. But Hunter Biden's lawyers decided not to go there, and you have this verdict. Instead of trying to go for jury nullification, it looked like Hunter Biden's lawyer instead tried to split hairs here, tried to say that, yes, Hunter Biden may have been a drug addict around that time where he purchased the gun, but not on that day. He had recently come back from rehab, and in his mind, he did not think he was an addict. He was in denial. But if that were to be believed, then that statute would mean nothing. That federal law that says you can't buy guns while you're addicted would mean nothing. If all it took were for someone who is in the throes of addiction to say, yeah, on that day I wasn't using, or at least I believed I wasn't an addict, then there is no statute. So you can see why the jury didn't buy that as a defense. Even the wording of the question on the form was subject to argument by the lawyer, Abby Lowell, for the defense. If you look at that language again, it says, are you an unlawful user of? So they focus on that first word, are, and they try to say are is present tense. And so it didn't matter that Hunter Biden had used drugs previously. It mattered only what he did on that day. Again, it would write the statute out of existence if you took that very narrow view of the statute. And Hunter Biden's own words in his own text messages were so damning, because the day after he bought the gun, he sent a text message to his drug dealer, a guy named Mookie, to score some drugs. That was just the next day. And then the day after that, he texted that he was in a car smoking crack. And so that's 2 days after he bought the gun. So it's really hard for him to say that he wasn't in the throes of addiction while he was buying the gun. And he was found guilty. This was a cut and dry case. The issue I have with it was not on the facts or the evidence. It's the fact that it's rarely charged. And I just don't think that it would have been charged had it not been a defendant named Hunter Biden. But it is what it is. We'll see what happens at sentencing. And then he now faces the case out in California, which is going to be tougher for him because a lot of people are charged with tax offenses. And so his claim of selective prosecution is not going to fly as well over there. And if you're guilty of tax offenses, you could really face prison time. Just ask Wesley Snipes. So hopefully this puts an end to the claims from Republicans that the Merrick Garland Department of Justice has been weaponized to target Republicans. Last time I checked, Hunter Biden was not a Republican. And in fact, can you imagine if Bill Barr went after Donald Trump's children? Can you imagine if they were charged with any crimes? Bill Barr would not only be fired, he'd end up in Gitmo. So this is Merrick Garland trying to be apolitical, and he appoints a special prosecutor to investigate Hunter Biden, someone who is a Republican, who was a U.S. attorney under Donald Trump in the Trump administration. And here's the outcome. But as a prosecutor, I can tell you that the jury just followed the evidence, they followed the facts, and they followed the law. And so here we are. That's the latest. I'm Dave Aronberg, aka the Florida Lawman, here on the MeidasTouch Network. If you like this video, please like it, subscribe, and leave a comment below. I love reading your comments, and I'll see you next time.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.